Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for April 26, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our first case, please?
Second one on page 2, Judge. In cause number 2022 DCV 2402, U.S. Bank National Association versus Marta P. Treviso. Announcement of counsel, please.
Harvey Erkslavin representing U.S. Bank, the petitioner, ready to go, Your Honor.
Okay, anyone here on behalf of Marta Treviso? Have we received any communications from Ms. Treviso?
Not me, Judge.
No, ma'am.
Okay, Mr. Erkslavin, we are set for default. I believe this was reset from March 22nd. You may proceed.
Judge, this petition was filed on October the 15th of 2022. The party was served on October 10th, 2022. There's been no answer on file. The original account is the same as the creditor, U.S. Bank. The account was opened on May 10th of 2018. The last activity was September 30th, 2020. Attached to the business records affidavit and pleadings is a last known address and the military ID. The business records affidavit indicate a total amount of $25,367.39. There's been no payments on the account. We're asking for a judgment in the amount of $25,367.39 at a 7.75% interest. And then we waive attorney's fees. It was for a 2018 Nissan Sentra, Sentra, I think.
And I was just going through the attachments here, the exhibits and the petition for default. Let's see, back. So the court will take judicial notice of the file and all exhibits attached to your motion for default and grant default in the amount requested. Mr. Erkslavin, if you haven't, I think we've had this reset once before, so maybe you sent over a proposed judgment. It would be helpful if you would email Ms. Hernandez that judgment now so she can forward to me and I can sign off on it, okay?
I think there's already one on file. Unfortunately, I don't have the capabilities or the knowledge of how to send it to you.
Ms. Hernandez, if you can look and see if we ever received one on this case. If not, we will touch base with you to see if we can get one.
I'll check, Judge.
Thank you. All right, in any event, it is granted.
Thank you, ma'am.
Thank you. Myrna, let's do maybe a 2-week status in the event that we have a delay on that.
Yes, ma'am.
Thank you. All right, thank you, Mr. Erkslavin.
All right, thank you. Bye-bye. May I be excused?
You may. Take care. Who's next?
Top of page 1, Judge.
Mhm.
In cause number 2022 DCV 3762, Wendy Reyes versus Carlos Avila et al. Announcement of counsel, please.
Good morning, Orlando Torres on behalf of plaintiff Wendy Reyes. Good morning, Your Honor.
Good morning. Let me see. Okay. This one is also set for a default hearing, although we have our motion for default judgment filed on April 6th. Were we able, was anyone here on behalf of the Avilas? Mr. Torres, how did you give notice of the default hearing to the defendants?
Your Honor, I need to ask my staff that, and I am currently in court right now. If the court could allow me to call to verify that. I do have the file here with me, but I don't have those notices in here. So I'd have to call to verify.
Okay, normally just FYI, that's one of the things I'll ask. If we have something filed so quickly, relatively quickly, April 6th to whatever, April 26th, I generally will do a reset just to confirm that we have some attempt at notice regarding the hearing. But if you'll check on that, we'll circle back to you and see where we are.
Okay, thank you, Judge. I'll do that.
Who's next?
Bottom of page 1, Judge. In cause number 2021 DCV 3044, Jorge Eduardo Ordaz versus Miguel Velarde Hernandez et al. Announcement of counsel, please.
Good morning, Judge.
Go ahead.
This is Daniel Gonzalez on behalf of Jorge Eduardo Blas.
Good morning.
Your Honor, good morning. Jim Mounts on behalf of Regal Carriers.
Good morning, gentlemen. We're set for a final status conference today. We have a jury trial in June. How are we doing? Oh, I just saw that. There's a motion for continuance.
Yeah, Judge, and I'm local counsel, but I understand we've been working to get this case resolved. And from what I understand, we have to set up for mediation. We're trying to get in with Judge Villa. Is that correct?
Do you have a set date?
I believe we do. I believe it's in June, Your Honor. I don't have the exact date with me.
Mr. Mounts, do you know?
Your Honor, Jim Mounts on behalf of Regal Carriers. I do know the plaintiff asked for a continuance. We agreed to it. The mediation is set for July 12 in front of Judge Villa.
Okay. So the first, I'm just looking at it, and honestly, things have been so hectic. I'm not sure if I reviewed this before. The request is to continue the June trial, get a new scheduling order to allow you all to mediate. What I would like to do, since we have a firm date on the mediation, is maybe just have you all come back for a scheduling status conference, grant the motion for continuance, obviously, but just check in with you right after the mediation. If at that point we know things are not resolved, then we'll look at a trial date. And I think I can still fit you in this year. So if not, it'll be early 2024. So I don't think it would be much of a delay. I'm setting one now. I just assume not set one now, since you all are going to take a stab at mediation.
Your Honor, we appreciate the court's courtesy, and that sounds like an agreeable plan on the defense side.
Okay, Mr. Gonzalez, you good with that?
Yes, Your Honor. I really appreciate you accommodating us.
7/19. So let's do July 19th at 10:30. Scheduling status conference. I will say this, anything in the interim should come up. I don't know that it will, but if anything should, just let us know. With that, we will cancel out the May 24th final civil pretrial, the docket call, the jury. We'll just go back to a scheduling status conference. Okay.
Thank you, Your Honor.
Thank you.
Your
You'll
Honor.
be excused. Take care.
Thank you.
Have a good day, Your Honor. Thank you.
You too. Take care. Who's next?
Top of page 2, Judge. In cause number 2021 DCV 3996, Paseo del Este Municipal Utilities, District Number 1 versus the City of El Paso, Texas, et al. Announcement of council, please.
Stephen Weller for the El Paso Water Utilities Public Service Board. Your Honor, good morning. I also have Sarah Labashowski, one of our attorneys, who is on today and will be arguing the response on our behalf. Good morning, Judge.
Good morning. Good morning. Mr. Davis, if you've been talking, I haven't even looked, but you're muted. So if you said anything, I didn't hear you.
I'm just here waiting for you to call, Judge. Good morning to you all there in El Paso.
Mr.
I'm here
Diaz,
on
I wasn't
default
talking.
judgment for
Mr.
Teresita Corral.
Mr. Diaz, we're not on your case, so I'm going to mute you, okay? See, Mr. Davis, if you're muted, then somebody else will come in and
Just take it over.
just take it over.
That's
All
right.
right. So, Mr. Davis, you're here on some motions to compel. Is that right?
Yes, Your Honor, the response was filed by the water utility this morning.
Mm-hmm.
And so I'm going to try to work through this because I think a lot of them have been resolved. The issue is that the objections that were filed don't apply to the requests that were made. And it's still not clear to me from the responses whether or not they're saying there are no documents responsive subject to the objections, or, even with the objections, there aren't documents that need to be produced. For example, request number 29 was a request for communications between EP Water and its third-party contractor regarding the wholesale water and sewer rates for the 3 tax years. And then the objections were that, overbroad and all the like, and privileges, and there are no privileges for EP Water communicating with its expert. There might be privileges with regards to Mr. Weller talking to their expert, but not with EP Water, not with the water utility itself. So when you have that objection in place, I have no confidence that everything that would be responsive has been produced. And the same is true with the rest of the requests that we're asking about. We were asking for number 30. Let me give you a quick background. So my client in 2003, these Paseo muds were created. It's hard to believe now with all the construction out there that in 2003 it didn't exist. And they negotiated with the water utility originally just for water and sewer service. And then as the communications progressed, PSP said, we are going to build out your infrastructure and you pay us back over time. So we have a 60-year contract. And as part of that 60-year contract, according to the contract, my client was not going to be charged the 10% surcharge that the water utility charges all of its retail customers, because the city wants some money from the PSB to be paid to it. And there's an ordinance from 1952, even older than I am, that says you pay 10% of your water sales to the city. And the contract in its exhibit says we don't pay it. Well, 20 years later, in 2021, almost 20 years later, there are new people at the PSB. And they don't know that the decision was made, not it was a mistake, but the decision was made not to charge wholesale customers, and there's only a handful of those, this 10% fee, and they look at it and they realize they're not charging us. And in 2021, they start charging the fee, and they changed another component of the water rate, which increases Paseo's water bill by about $750,000 a year. No communications, no explanations, just here. And we're in the lawsuit over whether or not they can do that. So what I'm asking is, what communications did you have with the other wholesale customers? Because they did it to all of them at one time. You know, what explanations did you have? Because it's clear from the documents, they never looked at our contract before making this decision. No one thought to do that. And whether or not it's proper, and I want to know, I know what they've told us. What do you tell everybody? Because it may be relative to our case. And they've objected, saying that it's, work product privilege and expert privilege. And I don't know that how these communications but would be privileged. And those are the kinds of objections I have, communication I have. They have responded, saying they've given us most of this stuff, but I want them to, in the respond to the motion to compel, but I want them to respond to the discovery, withdraw the objections, and make the affirmative statement that you've given us the responsive documents to these requests. We are not asking for any communication between Mr. Weller and his expert. And so Rule 195.5, which has been cited throughout, does not apply. And that's the basis of the motion, Your Honor.
So let me point out just a couple of things, and actually that kind of sounds somewhat straightforward. However, I just want to be very candid with each of you, is that these motions were filed when I was out of town. Obviously, the response was just filed this morning. So I can just tell you right off the bat, I'm inclined to reset this for 1 week, unless it is something very simple. I do want to give certainly not just the motions, but the response its due attention. So what I'm telling you is, if you want to just argue it today, that's fine. And then I'm going to get up to speed in reading your motions. Maybe Ms. Lab, I'm sorry, I'm going to call you Sarah. Maybe I'll listen to Sarah, and but you're not going to get an answer. You're not going to get an answer from me, I don't think, at the end of this hearing today. Okay. So I'm going to put it out there to you all. If it's so simple in a sense that you feel you can argue it today and leave me with the pleadings, and I will have a ruling, or I would like to set you out 1 week. You tell me, I'll take my guidance.
If we're going to move it, Your Honor, can we move it 2 weeks? I'm out of town next week. I'm going to memorial service.
Okay.
Next week.
Mr. Weller?
Your Honor, that's fine with us to move it, and I certainly understand that the court needs an opportunity to review. The only thing I was going to respond with briefly was the counsel gave you a thumbnail of their perspective of the case. So
Mhm.
I was going to respond to that for just a moment.
Absolutely.
sure.
Do absolutely argue whatever you want to argue today. I'm going to listen to you all, but I just know I'm not going to, even if I felt certain, I wasn't going to decide anything until I read the paper. Okay.
Yes, ma'am. Sounds good.
Okay.
So the utility and PDE, they have a wholesale contract. It was entered into in 2003. And their PDE is objecting to two features of a rate update that took part in 2021. And Mr. Davis made reference to both of them. One of them relates to a 10% city payment that the utility has been required to make to the city of El Paso every month since the utility was created in 1952. And so under Texas law, there's a chapter in the government code that says that a city, in lieu of having an investor-owned utility that provides water and sewer service, that a city can create a municipally owned water utility and then create a board, and that board has appointed members, and they hire a bunch of engineers and administrators to run a water utility. And it's basically, and then the law allows the city to fund the construction and maintenance of the water utility and the system that serves all the citizens of El Paso with bond revenues in part. Those laws that establish the ability to create bond revenues state explicitly that a city may, because they don't have an investor-owned utility, so they don't have all the ad valorem taxes that a city would usually get from an investor-owned utility. City of El Paso is foregoing all that. So the law says that they can create a transfer of revenues to the city of El Paso. And there are other instances where other utilities have done that. The Texas Supreme Court has expressly blessed it as something that is legal. It's laid out directly in the government code in multiple places. So what had happened was, for a number of years, the utility had been collecting the 10% and paying it over to the city, as occurs with every customer in the city of El Paso. The utility identified the fact that somehow the wholesale customers there'd been a decision made not to pass that on to them. But the reality was that they've been paying the 10% on behalf of all customers from the very beginning. And so they said, we're not really supposed to be treating these customers differently under the law. They moved all the wholesale customers over to paying the 10% at the same time. All the wholesale customers are paying it, and all of the inside city customers are paying it. The only one that's not is PDE. They have an interpretation of their contract where they say that they had carved out an agreement to not pay the 10% for the entire life of their contract. And our position is they're trying to make much too much out of a limited exhibit to the contract, which was really nothing more than a statement of the wholesale rates that apply to every wholesale customer. And the contract says when the wholesale rates change, their rates change. And so obviously they're objecting to paying it. It's not a small amount, but it's something that everybody pays. The second part of the dispute relates to something, I don't want to get too technical, Your Honor, but there's something called peak factors that are part of the wholesale rate setting process. And they're the part of the rate setting process for every customer. So during the summer months, the utility has to have larger pipes, stronger pumps, bigger infrastructure to have the capacity to pump water to all the customers during those periods when they use the most water. In other words, during the hot season. And so what in part of rate setting, what utilities all over the state of Texas do is they account for the cost to provide water during those peak periods. When PDE was first created, it had no users because, as Mr. Davis just said, there was no development, there was nothing. So there was no way to capture their peak data. And the utility did something that is done with all new wholesale customers. It uses sort of an abstract number. It uses a system-wide peak because that seems to be the best things you can plug in lieu of the customer's own peaking information until such time as they get enough information to use their peak. And at that point, we can accurately assess the impact they have on the system, and we can accurately charge them for the cost of service, which is what the contract says. So We moved them over to their own peaking in 2021, and they've objected to that too, because they say the contract doesn't explicitly spell out that they were going to pay based on their own peaking. But again, that's something that everybody else pays based on, and the law requires us to treat customers similarly. So I just wanted to give that brief response. Maybe it wasn't brief, Your Honor. Sorry about the time, but we're fine with the motion to compel being moved back 2 weeks. That's no problem at all.
4/26. So that gets us to May 10th. That should work. Let's do May 10th at 11 a.m.
And Your Honor, one other thing to bring up, because you normally bring it up when we have these hearings, is where are we at?
Yes.
We're set for trial July 14th. We got a week for that.
Mhm.
I think we can get ready by July 14th. It's going to be a lot of work, but that's not the problem. I don't think we can try this in a week.
Okay. Okay.
I think, yeah, but given the number of additional depositions that are being requested and what we've seen so far, and I've tried 2 jury trials since December that were way simpler than this, and both of them took into the 4th day, just on stuff that should have. I thought we were going to be a 2-day trial, and we're into our 4th day on both of those.
They're taking longer.
And this, I just don't see it in a week. I don't know
Okay.
how Mr. Weller feels, but I don't see it.
Your Honor, I would tend to agree with Mr. Davis. I think that some of the issues are technical, and it may take some more time than that. And Mr. Davis and I have both been working very hard over the last couple of months. We've taken a number of depositions. We have a number of depositions left to be taken in the case. So between working diligently on this case and handling our other commitments, I'm starting to get a little skeptical that we're going to reach the date in July, and that we wouldn't benefit from adjusting it to some moderate extent. But I guess we can continue to work forward towards that.
And we have been, trust me, we've been working really hard on this case.
Oh,
Yeah.
I'm sure you have. I'm sure you have. Thank you for the heads up in terms of the timetable. That's helpful because I actually think I know I have you all specially set, and just looking at the jury calendar, Marufo, are both dates pending in terms of jury selection? Because we have the 14th and the 13th for jury panels, but the 13th date says pending.
And
You have us on the 14th.
So, right, I have you all set, but I have two, I think it looks like I have 2 panels. What is it, Marufo?
we do have it, even if it says pending, Judge, it has been approved, Judge.
Okay, so I'm thinking that was probably for maybe some criminal cases that I might have at the same time, but you all are specially set.
Yeah.
Let me ask, we leave the panels as is, Marufo, but you're not asking me for 2 panels, and we're in Commissioner's Court.
No.
So Commissioner's Court is 100, a little over 100.
No, we're not talking about the number of jurors, though. I think given the fact that we're both public entities, we're going to need additional jurors. I mean, I haven't even gotten to that part yet of analyzing where I'm at. I'm just saying, I'm thinking it's more like 10 days to try it, and we need to move it out and get 2 weeks.
So I absolutely will accommodate that. I'll make a notation that we're looking at this being a 2-week trial. The reason I bring up the extra panel is because if you all are ready to start on Thursday and we can do it with 1 panel, I'm assuming that 100 is what you mean by we may need more jurors, right?
I think we need 100 jurors for the panel. I agree with that.
Okay,
Agree.
so if we could start on Thursday, are you all open to that, or are you wanting to start on Friday? And the only reason I'm bringing that up is because if we didn't need the Friday panel, we could start with evidence on Friday.
Well, I think what we're all saying is we need to move the trial back to another date.
Oh, so you want a continuance of the trial?
Right, that's, but Mr. Weller, we haven't had a chance to visit about this. We've been in depositions. Is that, 1, I think it takes 2 weeks, and 2, it's going to be a real brutal slog to get ready by that July date.
Well, then I'm going to let you talk amongst yourselves and see you. We actually will have, what am I saying? Maybe.
What do you got in November, maybe? Because I got a 2-week trial already set in October.
Okay, so the sooner you all can let me know if you want to move it, we'll see you on the 10th. Is that what I said for this hearing?
Well, I think we do want you to move it. Do you want us to file a formal motion?
Yes, I do.
Okay, we can do that.
And so we were already coming in on the 10th. I failed to see that for our final status conference. So we're just going to move the final status conference to 11 to continue to hear the motion to compel. I will also use that as an opportunity to get from you all an adequate timetable vis-a-vis the court schedule to get you a specially set 2-week setting.
You got it. Thank you, Your Honor.
That makes sense?
It makes it does.
Okay. We'll see you on the 10th at 11 a.m.
You got it, boss. Take care.
Take care, guys.
Thank you.
Sarah.
Oh, Mr. Davis logged out real quick, Judge. He still had another case on page 1.
Your Honor, may we be excused?
You may. Take care, Mr. Weller.
Yes, ma'am. Thank you.
Go ahead and call Mr. Davis then.
Yes, Judge.
Who's next?
Middle of page 2, Judge.
Mhm.
In cause number 2022 DCV 1297.
And show that one is being dismissed. Was that dismissed?
Yes, Judge, that was sent this morning.
Okay,
I had just asked them to appear to let you know that.
okay. Thank you. Next.
Right below it, Judge, in cause number 2022 DCV 2128, Teresita Corral versus Victor Ramirez individually at all. Announcement of council, please.
Good morning, Your Honor. Tony Diaz here for Teresita Corral, the petitioner.
Okay, I gotta imagine we haven't had, I think there was subservice on this case. We haven't had any contact from the defendants, have we? Victor Ramirez? or
No,
any- We
no,
have.
Judge, we have not, but folks have seen him around town, but we've not been able to get him served or find, any other way to try to get his attention.
Yeah, I did see the email from yesterday. I think it was with your default motion, and there was an issue with the service. You were not able to confirm anything regarding.
That's correct, Judge. He had stated way back, I want to say in May, that he was in the Reserve Guard or the National Guard, and that he would be finished with his duty in November of that year. And so we waited and held off, and people were, including, my client was seeing him downtown and also on other sites of construction.
How come
and
we
then
haven't been able to personally serve him if we're seeing him? here and
because he's trust me, Judge, we've spent a lot of money and time trying to serve this guy. He's I had to hire actually a private investigator. He's hiding, and the problem is this: that we contacted him and asked him to give us the information for his commander. I'm a former naval officer, and I was in the legal part of the JAG or whatever you call that, Judge Advocate General. It's been a long time, but when I tried making those contacts through him and through he wouldn't give me the name of his commander. He wouldn't give us the name of any way to prove that he was on the duty he was saying. Flat out, Judge, I've come to the conclusion he's not and was not. He's just basically trying to avoid because it's real simple. They used to have a database. You can't access that anymore, but it's real simple. All you do is call his commander and the commander will verify, and that's it. He won't give us any of the information to try to substantiate whether or not he is in the military.
Well, I'll tell you this, Mr. Diaz, without more than what you have attached as Exhibit B to your motion for default, I'm not inclined to grant it until that is verified by something other than your affidavit. So we can do two things. Either I'll rule on it now, or we can reset it for about 60 days and see if two things. If there is further attempt to serve him with notice of this hearing with the attached motion, or some other verifiable affidavit or documentation regarding his military service. Okay.
I'll do the best I can. I'm not too hopeful on this guy, but we'll do the best we can, Judge.
All righty, we'll reset this for 60 days. Thank you very much.
Thank you. God bless.
You too.
Bye-bye.
Who's next?
Back on page 1, Judge.
Mhm.
In cause number 2020 DCV 2345, David Jones versus El Paso Cowboy Construction LLC et al. Announcement of council, please.
Robert Riojas for the plaintiff, David Jones.
So now I know why. Now I understand why Mr. Davis logged out.
I cut and ran. Yeah,
Yeah, okay.
I paid my money. So-
We got his money, Judge. He's free to go.
He's free to go. That's right. All of Mr. Day, in fact, that's the only note I have on this case. All Mr. Davis clients are dismissed.
Yeah, that's right.
So,
I made it much easier for you, Judge. Did the best I could.
thank you.
Thanks, Judge. Appreciate
All
it.
right. Mr. Rojas, and is Mr. Beal?
I contacted his office, Judge.
There he
He
comes.
just logged in.
Okay. Poor Mr. Rojas, I feel for you on this one. Did we have any luck with your client? Let's get Mr. Beal in here. Yeah. My printer is really slow today.
Well, luck, I don't know, bad luck or good luck, but there was some type of luck.
Mr. Beal, are you there?
Yeah, Judge, I was in another hearing. I'm sorry.
No worries, no worries. So we're here on Cowboy Construction. Let me get an update, status conference.
So I had the opportunity to visit the lovely jail annex in East El Paso and spoke to Mr. Jones there. And I've also had some information from his public defender. There was a court hearing set for him on Monday. So the information from the public defender is that there will either be an acceptance of a plea agreement or there will be a trial. But in all likelihood, Mr. Jones will not be seeing the sunshine for some time. So I'm not sure how Your Honor wants to proceed. If Your Honor wants me to do a trial with an empty chair, I've done them before, but I can't give the court any more concrete information on when I expect him to be discharged.
So let me ask this. It wouldn't be my preference, although I know, we could do it. Are you looking at asking for a continuance of the May 5th trial date, Mr. Riojas, or no?
I think I would be required and consistent with my obligations to Mr. Jones, submitting a motion for continuance. Yes.
So then, we're just a few days out. If you're going to do that, please file it. I don't know what Mr. Beal's position is on that. I mean, I think I know, but I don't know.
But I will say, Your Honor, I will have more information after Monday as to the plea agreement, the sentencing, those types of things. It's possible he might get probation and be out earlier than I expect. So I don't have any more information than what I've already shared, but I think after Monday, I will have more information.
At the very least, in terms of timing, right? So if it's something where if he's getting probation and he's going to be out after, let's say, Monday or Tuesday, and you are better able to work up the case, obviously, I'm sure you would put that in the motion for continuance. And
We've done depositions. We've exchanged written discovery. I unfortunately, Your Honor, I was trying to remember, and Mr. Beal might recall better than me, if we've had mediation. I don't think we have. We might get some ire from you on that, but as far as my position is, we've worked up the case. It's been pending for 3 years now, so we could reasonably be ready anytime I have a physical body in the chair next to me.
Mm-hmm. Okay. Mr. Beal, were you going to say something? Because if not, I'll just see you all on the 3rd.
I'd like to ambush Mr. Riojas. The uncertainty in having to prepare for trial on the 5th would lead me to want to agree with any motion for a short continuance, because I don't know what to do, and I have a lot of settings around that day.
Right, as does the court. And so my thought is this, Mr. Riojas, after Monday, I would urge you to, if you're going to file your motion, please file it. This is what I want to know. If Mr. Beal opposes, is in agreement, number one. Number two, based on what you find out, what kind of turnaround time, the quickest turnaround time what I'm understanding is we can pretty much go straight to trial. I mean, we don't need any more discovery or anything like that. But yeah, if you all haven't mediated, the deadline to mediate was April 5th or April 4th. So I may also consider that in terms of a trial reset. Have you all gone to mediation, Mr. Beal? Do you recall?
Have we?
The fact that nobody remembers it tells me that you didn't.
I'm 72 years old, come on.
So I will definitely be looking at that in terms of a reset. Okay?
I think all that's fair, Judge, and I'll certainly let Mr. Beal know after Monday what, if any, new information I get from Mr. Jones's
Counsel.
incarceration.
Okay. All right. Well, if I hear from you sooner, great. If not, we'll see you on May 3rd.
All right,
Okay. Thank you, Judge. Thank you.
Thanks. Who's next?
Bottom of page 2, Judge.
Mhm.
In cause number 2019 DCV 3415, Yvette Castro et al. Versus Oscar Fonseca et al. Announcement of council, please.
Robert Ramos for the plaintiffs. Good morning, Your Honor.
Morning.
Mike McLean for State Farm, Your Honor.
Gentlemen, let's see. Do we have anything? Is this one of the cases that has a lien? No, what's outstanding?
It was I was working on, well, Mr. McLean and I were trying to resolve some issues regarding some personal injury protection checks from State Farm. We have worked those out. I have forwarded to Mr. McLean the signed order of dismissal, which I think he forwarded to the court earlier this morning.
Did I already sign this one? Myrna, did you get it or did I get it?
Yeah, we just got it to you 20 minutes or so ago, Your Honor.
And this is just a
There it is. I see it.
I
Okay.
just sent it.
Yeah. I'm sorry, you were going to say?
This is a partial dismissal as to Mr. McLean's clients at State Farm, and I'm preparing for information a dismissal motion in order for the individual defendants.
Okay.
And that
So,
should be,
I'm sorry?
I'll forward that to you later today.
Okay, so I am signing the one that pertains to Mr. McLean's client. We'll reset for 2 weeks in the event I don't have that other dismissal. Okay?
Sounds good.
Thank you.
Thank you.
Mr. McLean. Take care. All right,
Bye-bye.
Mr. Ramos.
Bye-bye.
Page 3, Judge.
Mhm.
In cause number 2020 DCV 3991, Yolanda Rucobo versus Morniel Inc. Fendi et al. Announcement of council, please.
Yes, Your Honor, this is Joshua Govea on behalf of the plaintiff, Yolanda Rucobo, here on behalf of Daisy Chaparro.
James Lawrence here on behalf of Dina Roderick for defendant River Oaks El Paso LLC.
Good morning, Judge Bruce Gomez for Moriel et al. Ready to proceed?
Okay, let me make sure. Give me a second. Who did I miss here? Mr. Govea, you're here on behalf of Ms. Chaparro?
Yes, Your Honor.
Okay, sorry. I was signing that order. And Mr. Lawrence? I'm sorry, could you repeat that, please?
Yes, ma'am. Or yes, Your Honor. I'm here on behalf of Dina Roderick.
Okay. And Mr. Gomez. All righty. Okay, so we're here on, let me get your case. Sorry, that's what happens when I sign orders in the middle of hearings. So let me go back.
This is where the plaintiff passed away, Judge.
Passed away, right? And I remember Ms. Chaparro. I feel like there was a whole set of different faces last time.
Mark Davis was here last time, yeah.
Everybody was different last time.
Yes.
Which,
We're tricking you today, Judge.
I know. Why are you doing that? I just and again, okay. Lawrence, okay, and then I'm just going. Okay, I think that's it in terms of the things that have been filed. Okay, so we're here on a motion. I'm not going to pronounce it. Mr. Lawrence, it's going to be yours. We're also here on a final civil pretrial. So go right ahead.
Yes, Your Honor, we are, our motion, sorry, Vices, I believe is how you say it, but I probably mangled Latin. We've settled this case. We would just like to know who to pay. Plaintiff's counsel has not provided us with any information on the air or anything else. And so we filed this motion in an attempt to get them to let us know who we can pay to make this case go away.
And so I think there were some things outstanding, Mr. Govea, from the last hearing. Let me ask, what have you all done with respect to Ms. Rucobo? I can't remember what Ms. Chaparro was talking about last time around.
Yes, Your Honor. So right now they're working on communicating with the family because they're still working on deciding if they're going to probate and how they're going to proceed. So we're working on communicating with them to see if they're going to proceed or if we're going to have to withdraw or how we're going to proceed with the case.
So I feel like that's where we were last time. And so suggestion of death into the record and cite an order for the heir executive administrator of plaintiff to appear within 30 days to show cause why they should not. Okay, so in terms of having that 30-day deadline, Mr. Govea, I mean, that doesn't sound like it's something that you all will be able to accomplish, or I don't know. I mean, I'm not understanding if there's any movement.
It makes it a little bit tough, Your Honor, because since Ms. Chaparro is the lead and she's on maternity leave right now, I know she's coming back in a couple months, so it does make it tough. We'll work on it, but I think you're right as far as the timing might be pretty tough to get an answer from them. Since her death it happened in January 19th, 2023 of this year, so it's pretty recent too, so that's always tough on families as well.
So are you making any requests here?
I guess the 30 days would be tough on there. We have some more time to do so, to get that from the other family to make sure to see how they want to proceed, if they're actually going to probate or not.
Mr. Gomez, do you have any input?
Judge, I'm just concerned that we keep showing up to these statuses. I keep billing my client each time. I know it's difficult losing someone, but I mean, it's been 4 months since the passing, and I think we should know by now if they're going to probate or not. I think we should just set it for a DWAP and let this case be dismissed if no action is taken, or if Ms. Chaparro is going to withdraw, which was the same thing she said last time.
Yeah, it looks like we were here February 22nd for the final civil pretrial. And that's where I think some things were up in the air, but I guess that's relatively soon, probably about a month after they may have had notice of her passing. And then, of course, we just come up with a bunch of hiccups.
And then again, I don't know how much is in the estate. If it's just this money, it's probably going to be more expensive to probate than to get this money, in my opinion.
Anything else, Mr. Lawrence?
No, Your Honor, I agree with Mr. Gomez. All right, we keep coming here. All right, 30 days for them to either figure out if they're going to probate it or determine who the heirs are. If there is no money in the estate, because I know there's a limit, you don't even have to probate it. We even know who the heirs are, and we can sign off that way. I think 30 days is more than enough time for to do that, since again, they've known she passed away in January and it is now April, almost May.
Okay. Mr. Govea, how is it? How are you? I mean, are you handling her docket? Is that what's going on, or are you? Because I mean, you're appearing today and, you know, I guess the notice of her unavailability was filed in March. That was a month after we had our last hearing. I mean, are you working on this case or are you showing up for the hearing?
I'm showing up for the hearing, Your Honor.
I am not in line, Mr. Lawrence, just in light of the circumstances with Ms. Chaparro with your timetable. But I am going to reset this for 60 days. I am going to reset it for the motion hearing, final civil pretrial, and DWAP.
Perfect.
Okay. So Mr. Govea, I'm not sure if that aligns with Ms. Chaparro coming back, but somebody needs to get working on this. So we have an update because it appears to me that we went from February to April with nothing really happening. And that's not good. So, but I get it. There's a couple different things happening here. So we will see you all, what did I say, 60 days?
Yes, Your Honor.
Yes,
Yes,
okay.
Your Honor.
We're gonna come back in 60 days on the exact same settings with the additional DWAP. Okay,
Thank you, Your Honor.
Thank you, Your Honor.
thank you for your patience. Take care, guys.
May we be excused?
You may. Who's
Thank
next?
you, Your Honor.
Second on page 4, Judge.
Mhm.
In cause number 2023 DCV 0224, Wilma Yarbrough versus the State of Texas, Antonio Ventura. Announcement of council, please.
Claudio Flores for the defendant, Antonio Ventura, ready?
Have we had any contact with Wilma Yarbrough? I know this was a reset, I'm remembering that. I don't remember how long ago it was. Was it 30 days? Have we had any information on Wilma Yarbrough? Any contacts?
Not
No?
myself, Your Honor, no.
Mhm.
No, ma'am.
No, Judge.
So this was set for a status. It wasn't set for. I didn't want it set for a DWAP. Mr. Flores, do you recall from the last hearing?
She filed this handwritten lawsuit without an email address. So
Mhm.
I'm not sure if she got notice, the way I did, of this order setting hearing that says your case may be dismissed for want of prosecution for failure of any party seeking affirmative relief to appear for any hearing or trial.
Can anyone see if we mailed out to a physical address or if we had an email notice of this hearing?
Judge, I did find an email for her. I did send her a notification when I sent out
The Zoom?
the Zoom on Friday, Judge.
Where did we get that email?
I got it off of the Odyssey.
Do we show that we mailed a notice of hearing? Who is this?
I don't know, Judge.
Well, let's bring them in and find out. Make sure it's not anybody that has. So did we mail anything to Miss Yarbrough? Anyone? Ma'am,
Okay.
what are you here on?
Let me, give me 1 second. I'm her caseworker. I was just setting her up because she needed an office space. Can you see her?
Hi. Yes, but who are you, ma'am? Oh, it froze. I have a feeling this is going to be her. The connection is very bad. Are you there?
Yes, ma'am. Yes, I have a court date today at 11 o'clock.
What is your name, ma'am?
Wilma Savage. Need my paper. Okay, sure. Wilma Savage. This is for court number 210. Yeah, district court live 17-210.
Ma'am, is your last name are you Wilma Yarbrough?
Yes, ma'am, that's true. I forgot about that too. Yes, ma'am, I am. I got remarried. At that time, when my dad passed away, I was Miss Jarbo.
Okay. And so now Miss Yarbrough is appearing remotely as well. I'm sorry, Miss Yarbrough, the connection is not the best. And so you may hear me sometimes ask you to repeat some things because it was breaking up quite a bit, okay?
Yes, ma'am.
So we are here on a case that you filed a lawsuit against, is it the state of Texas, Antonio Ventura, is that right?
Yeah, Antonio Ventura, yes.
Okay, and it appears, let me see.
I don't see him.
It appears, well, Mr. Claudio Flores is here as an attorney. Let me see. Representing Antonio Ventura. Let me go back to the lawsuit. So we were scheduled today for a status conference, Ms. Yarbrough, because there was, I guess, some confusion about how we could get you notice of settings. Okay, so are you not going to hire an attorney?
I was gonna ask you if you can appoint me an attorney because I don't have money.
I do not have the ability to appoint an attorney for you in a civil matter. Okay, if this was a criminal case, then due to your indigency, I could appoint someone. In civil cases, I cannot. Okay. And so what normally will happen in my civil cases is we will have an initial hearing after the parties are served to get a scheduling order. And what that is, it's a slate of dates that lead up to a trial setting if you are requesting a trial. It also will contain an order for the parties to go to mediation by a certain date. Based on your representation here about, are you going to look for an attorney or?
Well, at this time, you know, I have money coming in, but I'm not receiving it at this point yet. But it is coming in, and I can't get to it right now. But mainly, what I like to do is I like to see if I can get him moved out of the house so we can all sell the house because everybody in my family is willing to sell. So I'm here to represent me and my family. And there's only 5 of us left. The other 3 died. So with my mom and dad. But he left the house to all of us. Antonio Ventura is, okay, he's from Andrea Ventura, which was a maid service. So he's from Mexico. He is not from here.
But bear with me 1 second, Mr. Yarbrough. I'm just looking at your initial filing back from January, okay?
Yes, ma'am. Thank you. Ma'am, I wanted to ask you a question, please. Do I need to get a petition of all my families that they're willing to sell?
I really can't advise you, as I mentioned.
Oh, yeah, because you're not, yes, ma'am, you're right.
I'm not
Yeah,
here
I
attorney,
apologize.
ma'am, but I'm not quite finished with your document, with your plea.
Okay, thank you, ma'am.
Also, we do have a mailing address and a phone number there.
Yes, ma'am, on all of them, yes, ma'am. And they're all still there.
Did you receive our email?
I received one email, but I'm not very good with emails. I'm still old school, still trying to learn.
If you would, please, the court bailiff and the court coordinator are also on this Zoom proceeding. If you will confirm for them that we have a proper email for you, just because for the most part, we are conducting these proceedings on Zoom like we're doing today. And so we can give you notice through the email as well as through e-filing. And I will just also throw out there, if for any of these proceedings you prefer to come in person, you need to let us know so that we can have the hearing in person. Okay, so let me go ahead and go back to your pleading.
Yes, ma'am, thank you. Okay.
I confirmed.
Thank you.
This here, I'm asking the court to remove him, or he can buy us up.
This Flores, that's his attorney. Claudio Flores is his attorney.
Yeah.
No, I'm gonna try, yes, I'm gonna try to kill one, yes.
All right, so for the court's purposes right now, I don't see, okay, we do have an answer filed. Okay. We had a status conference back in March. We may not have been able to get you notice of that, Ms. Yarbrough. We're at a status now. I'm not necessarily inclined to go forward with some type of scheduling order right now until I can get some type of confirmation of whether you're going to seek the assistance of an attorney. And I will give you an opportunity.
Yes,
I will give you an opportunity to do that. Mr. Flores, I'll hear from you right now if you have anything for the court.
Your Honor, just that we have filed an answer and have alleged the defective parties. This lawsuit appears to be related to an inheritance that a house that my client is maintaining and paying taxes on that belongs to the plaintiff and several other siblings pursuant to an heirship determination. So to do a partition, if that's what she wants to do, she's got to serve the other parties that have an ownership interest in the property. If some of them have passed away, she's going to have to serve their heirs or beneficiaries if they will. So we don't have all the parties to be able to move forward on a partition if that is what the lawsuit is requesting.
Okay. For the court's purposes, right now, I am going to set a scheduling status conference in 60 days. Okay.
That sounds good. Thank you, ma'am.
And it will be, you will receive notice electronically, so through the e-filing, and we will also send you notice via email. So Myrna, as soon as we get that notice of hearing, we need to, although it goes through the e-filing, we need to email it to her directly as well. Understand that, Ms. Yarbrough, if you're going to seek counsel, then they need to enter an appearance here in this case, and then they can appear on your behalf for the hearings. But I'm going to give her a minute, Mr. Flores, to see if she's able to retain the assistance of an attorney. If
Yes,
not,
ma'am.
we will still have the hearing, and I'll address anything at that time. Okay. Any concerns?
Thank
All
you,
right,
Judge.
Ms. Yarbrough, thank you for appearing. I know some of these processes are a little different because we get on Zoom, but hopefully it's convenient. As I mentioned, if at any point you do not have the ability to appear via Zoom, please contact the court staff, the court coordinator, and we can arrange for an in-person hearing. Mr. Flores, I wouldn't necessarily require you be here in person, but we can set her up on Zoom here in the courtroom, okay?
Yes, ma'am. Your Honor.
All righty. We'll be back in 60 days. You'll get notice of that hearing.
Thank you, Judge.
Okay, ma'am, Judge.
Yes,
I had requested if you guys could mail me the information.
Sure.
My phone has been acting up on me, and sometimes I'm able to receive emails, sometimes I'm not. So I prefer you could mail me the information of the date and all that.
Sure, we will send you, I'm going to send you notice every which way we can, which will include a direct email to you, e-filing, and a hard copy mailed to your current address. I will tell you though, you may need to contact the court to make sure, well, let me see, your petition has an address on, oops, On Hayes?
Yes,
Is it on
ma'am.
Hayes? Okay,
Yes, ma'am.
so we do have that as part of your petition. We will mail notice to that address as well.
I appreciate that. Thank you very much.
Absolutely. If there's nothing else, then you both are excused.
Thank you.
Okay, thank you.
Have a good day. All
Likewise.
right, Mr. Torres is still waiting.
Hi, I'm Mr. Torres paralegal. We had a court hearing, but notice was not sent. So we would like to ask for a reset.
Reset of 30 days. Thank you very much.
Thank you.
Why is Mr. Huffner sitting over there? Mr. Gomez, what are you doing?
We called his case earlier, Judge. That was the one